Hello, everyone. My name is Sal Conti, and I am in the Fore's Business Intelligence and Insight Group. This meeting, as you may have heard, is being recorded. On behalf of my colleagues, Nicole Rizzo, also on the BIM team,
Hello,
and
everyone.
Allison Pepper and Amanda Anderson from Fore's Government Relations, we'd like to thank you all for joining us today. This is a joint meeting of two Fore's committees, Production Business Affairs and Operations, and Advertising Legal Affairs. We do want to recognize our committee chairs, Jessica Nugent and Heidi Young, respectively, for the guidance and resources they provide to Fore's in serving in those positions. So thank you both. As an example, Jessica and I were discussing challenges in addressing AI in agency commercial productions. This led us to discuss our regular collaborations with today's presenter, Chiara Cummings. Chiara is the Associate General Counsel Americas, Commercial, Legal, and Business Affairs at WPP, which has now brought us to today's presentation, which is using generative AI safely and responsibly. But before we begin, let me cover how we will manage today's session. And I would ask everyone to please make sure they're on mute. So if you have any questions or comments during the presentation to be recognized, please either use the chat or raise your hand. My colleagues and I will be monitoring both, and we'll call on you. Please remain on mute again, unless you were called on. That will keep all the sounds down, obviously. Ms. Cummings has allowed us to share her presentation. The presentation and meeting video will be distributed to committee members within a few days following the meeting. And before I turn it over to Chiara, does anyone have any questions, comments? All right, then we will turn this over to Chiara. Chiara, thank you very much.
Thank you so much, Sal. And thank you for inviting me to speak to this group today. As Sal mentioned, I'm in-house counsel at WPP, and it's really a pleasure to be able to address the cohort of people we have on this call. So the topic, hopefully an exciting one, of generative AI. We do anticipate and hope that this topic is going to be engaging and will prompt meaningful discussions. So please feel free to ask questions, or even if you just want to make comments throughout. We do intend this to be informative and also interactive. So please do feel welcome to make contributions. So artificial intelligence, so what? Artificial intelligence has been around the advertising industry and many others for decades, for a very long time now. When we think about traditional AI in terms of our advertising industry, we might think about machine learning systems that use predefined sets of rules that are used to analyze large sets of historical data in order to create an output, to perhaps create a prediction about the future. What I see, and I'm sure what a lot of you see, is systems that might create predictions about consumer behaviors, about spend, about the right price of a product, etc. So that has been around for a while. We're all sort of very familiar with that. But what about generative AI? How is that exactly different? So if I could sum it up, generative AI does not use these predefined rules in order to create the output. Rather, there's this large subset of data, and these Gen AI systems have learnings based on sort of the patterns and behaviors that they view from the data in order to create an output that is brand new, that has never ever been created before. But today I'm going to use these 6 boxes you see here on your screen to, at a high level, guide our discussion. Intellectual property rights will be a main theme throughout this entire discussion, and we'll touch across all of these issues. We're going to look at the underlying data for which these Gen AI systems are trained on, the prompts that go into these systems by the users, and then of course the outputs and the big issue around ownership. And we'll also be considering issues such as privacy and security and confidentiality, for which are issues that we at WPP, and I'm sure across all of your agencies, constantly have top of mind in terms of the commitments we make to our clients. So first, let's look at underlying data. At WPP, when advising clients, we're always looking at not just the systems themselves and how good they are, but how they're exactly training and using the data. When, I guess you can call it the AI boom, at least it's not Gen AI didn't start, like I said, a year ago. Those sorts of platforms were being generated and innovated over time. But for the purposes of this discussion, the boom that we saw about a year ago, the technologies that were really at the forefront of that boom, as in the technologies that were perhaps the most creative, that had the most artistic outcomes, that were really innovative and loved by our agencies, were the platforms that had a huge subset of data from which to be able to pull from. And in order for those types of platforms to have such a huge subset of data, they had to use methods, whether it was sort of data mining or web scraping or other methods, in order to collect such a huge amount of data that it was arguably collected without permissions, which is this issue that we struggle with at the moment where we are today in terms of copyright in the or any intellectual property rights that may exist in the underlying data for which permissions have not been granted. So a lot of the systems at the beginning, at least from what I saw, the systems that would garnered the most attention from our agencies were those really were the systems that had the most amazing output. And again, they might not necessarily have gotten there by getting the right permissions from the underlying owners of the data. And still to this day, I'm constantly having conversations with our agencies about the balancing act between using platforms that might create the most innovative, detailed, amazing, artistic outputs that may not come with many terms and conditions that are protective of the user or the agency and our subsequent clients, versus platforms that perhaps do have assurance. They're underlying those platforms, there are assurances about the whereabouts from where these assets that they rely on have been taken from, that they've gotten the right permissions, that they do stand behind and provide indemnities. So we're always having conversations about the types of platforms and the issues we're thinking about in terms of risk when advising agencies what platforms they should or should not be using. Because on one hand, we obviously want to be at the forefront of innovation and technology, and we want them to be using the best platforms. But at the same time, we have obligations to adhere to with respect to protecting the interests of our clients and not putting them in a position for which we're producing infringing work. I want to go over the Coca-Cola examples that we have here. These were on the right. You can see the prompts that were made, and on the left, you can see the images that were produced based on the prompts. The first input that we made and the output, hopefully this is not a shock to you, we put in a painting of a Coca-Cola bottle. We used Coca-Cola, the trademark protected name. So it was not surprising that the three images that you see displayed there have Coca-Cola very visible, including on the label, and also obviously the shape of the bottle, which is also protected by Coca-Cola. So we thought, okay, how can we sort of test the learning of this system? We don't want a Coca-Cola bottle, so let's just use the generic term of cola. So you see in that second display there, even by using the generic term of cola, you can see that based on the subset of data and the learnings of this particular platform, which I think was DALL-E, but honestly, you could do this exercise with many different platforms, and I think you'll get a very similar outcome, for which you can very clearly see that there are infringement and intellectual property rights issues with all three of those photographs. So but then we took another example and we said, let's try to get this system away from the Coca-Cola company altogether, and let's input cola using just the generic term and asking it for pictures with the blue label. And again, clearly you can see here infringement issues everywhere. The cursive of the text, the shape of the bottle still, I mean, even the one on the left almost, if you squint, arguably, says Coca-Cola. So I thought this was a really interesting way to display this and perhaps sort of open up some thoughts at the top of this discussion about having some sort of insight into how these systems are trained and how they learn. What's the difference? How do they get to the output? And I think this is just a really nice way of sort of methodically looking at perhaps the learnings and insights into these systems. And again, I think it goes without saying, this just also highlights that human intervention and oversight is of paramount importance in the use of AI throughout the entire process. Without such oversight and intervention by us, us here on this call and our colleagues, that is when we potentially lose control. So just like in our everyday work now, before what I call the AI boom for our industry, just like we had oversight then, that oversight does not go away. Arguably, it gets more intense. I've also highlighted here the recent lawsuit, which I'm sure many of us on this call have come across. It was filed recently by the New York Times against OpenAI and Microsoft. And at the crux of this lawsuit is basically copyright infringement. The New York Times has alleged that OpenAI's system of ChatGPT creates outputs that are virtually identical or arguably identical to articles that have been published in the New York Times and written by their journalists. So while copyright is at the center there's many issues with respect to that case, but copyright really is at the center of it. So this notion of taking something obviously by the author of the original work for which you do not have permission and then recreating it in another way that isn't distinguished enough, or it might just be blatant copying. Since I've been reading about this case, I've been taking a step back and thinking, so there's one thing to have sort of straightforward copyright. And there we have copyright law, which protects authors of original works with respect to that. But in this case especially, it shows that it's more than just taking what's on the paper, sort of the black and white words, and then replicating it. It's so much more than that. What is being taken is also the creative underlying processes of these journalists, the time, the effort, their creative thinking, etc., that goes into creating these articles. So what's being stolen or taken really is so much more than just looking at it from a black and white sort of 2D dimensional perspective. It's a lot more dimensional than that. And I think this really echoes in our industry when we're speaking to across our agencies and with clients, because who we work for, or who we work with, rather, I say for because I'm an attorney, I support our teams. But I see so much passion and so much creativity that in my wildest dreams, I couldn't do what so many of our teams do for their clients. So with respect to AI and the integral part that it plays in this whole copyright discussion, I think it just goes so much further than that. And that is something that I'm constantly thinking about when I'm speaking to our teams about their creativity and what copyright means, and potentially, the power that these generative AI systems could potentially wield over our creatives. Again, it's one thing to take something and sort of replicate it, but what is being taken is so much more than that. And I think that really resonates with our agencies when looking at their own work, and also, honestly, when looking at other work for inspiration, for example, by using OpenAI in their concepting. So now I just want to talk about the input prompt. So there's a lot of discussion about sort of who owns them. Does the user who made the prompt into the Gen AI platform, do they own it? Does the platform own it? If the user owns it, can the platform use it? And the reason why this is important is because always, whether at whatever stage of a client work that we're implementing the use of Gen AI, it's important to have a high regard for the type of data that we might be inputting, that our agencies are inputting into these models. So there might be, sometimes behind sort of closed doors, there might be this sort of concept of, well, no one else is going to see my input. But we have to be mindful, and I'm reminding the agencies constantly that what is inputted, unless you know otherwise, or unless there is a closed environment, for which fortunately at WPP on our creative studio, we do have a closed environment around ChatGPT and some other platforms. But unless it's in a closed environment, it's very likely that those prompts that you're putting in are just going towards more learnings. It's just being ingested by these systems to obviously make their platform better and richer, but at the cost of what? And I think this gets even more and more potentially dangerous when we're not just talking about text prompts, but the platforms have come so far. Just the innovation of the most sort of recent year is pretty astounding. But the prompts can be videos, they can be images, they can be voice, speech, and other sort of audio prompts. So to be mindful of what we're putting into these platforms is something that I'm constantly making reminders of. And I think it's important also to touch on the distinction, or whether or not there should be a distinction drawn between inputting client confidential information, which is non-public, versus just inputting information about our client, which is public. Because we do have a duty to our client, even if we're inputting and using data that is public, it's not under any sort of particular obligations of confidentiality with respect to the definition of confidential information under the contract. But think about, it's one thing to have, again, you input actual non-public information, but we also need to be mindful of our clients and their desires with the information that is out there about them. If they have already released a campaign and there is a bunch of information out there, there's taglines, there's slogans, and we've done all this wonderful work for them, do they want us sort of inputting a video campaign, the taglines that they use? It's public information, it's not private, but the extent of the information that we might use, which is owned by our clients, regardless of whether it is public or not, I think consideration needs to be made there about what we can or cannot input. And it all comes down to transparency and having those discussions with the client, because at the end of the day, they have the ownership rights over it. And as their agency, we really need to, we have their needs at the forefront when we're constantly thinking about these issues about confidentiality. It's not an agency issue, it's a client issue, and one that we should loop them into consistently. There was, about a year ago, I think it was, some Samsung employees accidentally uploaded some trade secrets into ChatGPT, just in the ordinary course of their work, and just experimenting and playing around with the platform. I think there was they gave the example of some internal meeting notes which were inputted into ChatGPT, and in another case there was some source code which was uploaded. Samsung was obviously reacted to this and greatly limited the use of their employees, greatly limited the ability of their employees to use ChatGPT and other free-to-use software in this space. And since then, there have been similar moves by other large companies, especially in the tech space, to limit the ability of their employees to use these platforms in their day-to-day activities. So it's an interesting sort of juxtaposition, the use by employees just trying to sort of test and work around versus the use that we see by our agencies, because to protect at the end of the day, confidentiality is the main sort of theme there. But what we're protecting, I think we have a higher duty because of the information that ultimately our agencies are likely inputting in order to create outputs for our clients for these platforms. Okay. I hope to spend a bit of time on this slide because I think this is where so much of the focus is consistently. It's about the output. So I wanted to sort of touch on the underlying data and those issues there, and obviously the input prompts, because that sometimes gets forgotten, but we all are about the output. And I think one of the main issues when we're looking at the output from these amazing systems is ownership. and when we're talking about laws and regulations that are in place about ownership and how those rights can be attributed, they vary depending on region. So today we'll obviously focus on the US, but I just do want to note that the US does have the laws and regulations in the US aren't necessarily reflective of laws across Europe and the UK, for example. But when it comes to ownership, I think the bottom line is, if ownership rights aren't able or aren't capable of being given to the output, then no one can own that output. If ownership rights cannot subsist in an asset, then no one can own that asset. And so I take a step back from that and I say, because I'm always advising the agencies, look at the terms and conditions, look at the terms and conditions. And I'll come to in a minute a system that we have in place at WPP, our traffic light systems. We've taken a bit of that responsibility back from our agencies. But in looking at the terms and conditions, as lawyers, we can sort of see this language from a mile away, but perhaps others cannot, where there is really clever language that is often embedded into many of these platforms, which says, to the extent ownership rights can be granted, then you own it or we own it. Or to the extent the law permits, then you own it or we own it. I mean, sort of, clever ways of circumventing or, going around the issue at hand, which is, well, who owns it? So what does the law say here? There's been so much commentary over the last year. The USPTO, they brought out a note on this pretty early into last year. There's obviously, in terms of sort of regulations, the executive order from October of last year, and there's been so many other bodies which have come out with opinions. And outside the regulatory space, people in our industry also sort of have opinions. But at the end of the day, what has remained pretty consistent, at least from the sort of legal perspective and looking at this, is that the Copyright Act is clear, and that has been reinforced. The Copyright Act is clear in that only a work that is created by a human can be afforded copyright protection. So work created by a machine, technology, even an animal, if you remember that monkey taking a selfie case, no ownership rights can subsist in that asset created by a non-human. So, like I said, there's been so much commentary along the continuum of, but so who owns that? How does this work exactly? The technology can't work without the input from a human. What about if the human's input is so intricate and that the text prompt, for example, is paragraphs and paragraphs long, and has created such a unique, one-of-a-kind output? Surely there's a nexus there, and there can be ownership of the input in connection with that output. And the law still says no. And watch this space, probably not soon, but who knows where the Copyright Act might go in the future. I can't see it changing so dramatic, with such vigor. But again, I've said less crazy things in the past and they've happened. But a lot of why that is because the Copyright Act attributes, or the sort of narratives around why the Copyright Act attributes ownership only to a human work, is because of the creative process, and which is sort of similar to the issue I was talking about a minute ago about the creative process behind journalist work, etc. But there's an appreciation of the law behind the creative processes and those choices and those decisions that are made in order to arrive at that asset that can then be protected. And the commentary around the law is, well, who's making those decisions? It's actually the technology. It's actually these Gen AI platforms that are actually making these choices based on they're making them very quickly, but it's the platform itself that is making those choices, not the individual. So I think it's a really, really, really interesting topic, because there is, and I think it's got a long way to go. I think it's got a long, long way to go. And I think what I mean, in my opinion anyway, I think we're going to see some sort of a hybrid, whether or not it's sort of full ownership rights or not, but some sort of attribution towards the output based on, again, the amount of input by the human, because again, that one can't exist without the other. One can just be a very regular prompt like we did before, Coca-Cola bottle on a sunny day, or there can be really intricate prompts for which, again, that nexus between the prompt and the output is so much stronger. So how can you separate the two and say that there is no ownership by that person that inputted that prompt? Yeah, I think it's, again, it really interests me. I have a couple of examples here that I want to go through. Deepfakes, again, a huge issue, or a huge topic, I should say, not an issue, a huge topic that is discussed, because there's ways of infringing people's rights and leaning into this concept, and there's a way of doing it correctly with permissions. Obviously, the Joe Biden robocall was not done with permissions, and an investigation was commenced by the government in response to that. But a gentleman just used 11 Labs, the speech Gen AI platform. So he inputted. So his prompt input was Joe Biden's voice. He created the text, and within, I think he said, a matter of seconds or minutes, had this outputted statement in Joe Biden's voice. And he used this to make calls in New Hampshire to encourage voters to not vote. And then when during the investigation, before things were uncovered, he then accused, or rather publicly said, that his then running Democratic opponent in the primary had obtained his services in order to do so, which was complete bollocks in the end. And he eventually sort of said, okay, hands up, I did it on my own volition. But it just really goes to show how, not only how quick the output can be performed, but how dangerously and this path of using deep fakes can go. And I'm not sure how many of you have seen across your agencies sort of influencer AIs and those issues around there. I kind of see deep fakes and influencer AIs as having a little bit of crossover. So when I'm asked questions about influencer AIs, I'm constantly thinking about the same issues that I would think about with respect to deep fakes. And we can perhaps have a discussion and talk more through sort of my rationale and reasoning there. But yeah, these tools are powerful. These tools are powerful. And it's no surprise that at least the politics in the US are really heavily focusing on deep fakes and the ability to not take advantage of, without permission, someone's likeness, their voice, their image. And a lot of the bills that have been sort of introduced to potentially be law really have looked at this potential issue, because I think this, outside of our advertising world, these issues of being able to so easily and readily create these deep fakes has much larger sort of public policy consequences potentially, for which the government is obviously mindful of always when presenting bills. So I do see deep fakes being quite a concentrated topic politically.
Chiara, sorry to interrupt, but this might be a good time to just stop and ask the folks, does anyone want to, on what we've covered so far, comment, questions that you want to bring to the group? Share with us? Anyone? If you do, just unmute and we'll cover that.
Hi, my name is Kristen Calabro. I'm from the Landor Agency, and I just had a question for Chiara, based on what you were talking about in terms of the ownership around something created by technology versus created by a human. I know our design teams are often using AI tools to generate during the exploratory phase and create multiple concepts to help them get to a final design output. Is there a threshold, per se, if we take a concept that AI generated, and then we took it, we redrew it, we evolved it, we refined it, is there a threshold at which point that output becomes human created again, where it would fall under the ability to be copyrighted? Or is if it came out of a AI generator, it's moot forever?
That's a really good question. The answer, just at a high level, no, it's not. It's the answer. The ability for copyright to attach to that derivative work, if you will, is not moot forever. So it actually, I really like that question because it doesn't differ too much from how we just generally look at copyright. So it's a very sort of gray area, and there's no black and white. But generally speaking, with copyright, if there is a work of authorship and a separate third party takes that work of authorship but makes so many changes for which there's so many distinguishing features that the law would consider it a completely separate work, even if it was sort of originally based on something that is and remains protected, then the law will see that as different and there's no infringement, and that new work can be afforded copyright protection. So in similar vein, again, it's funny because with all these issues that come up with Gen AI, there's so many, all of the issues that we already think about in the creative world are still sort of there. So yes, they absolutely can. And there's no black and white, okay, as soon as you make that color change, or as soon as you change that corner, then that becomes a new distinguishing feature for which is considered in the eyes of the law a separate asset. So it really is an exercise of knowing what's out there, knowing how the perhaps precedent in litigated cases, sometimes just an untrained eye asking the creatives about, what have you done to exactly make it different? But the one difference there, I think, with that example is in sort of pre-Gen AI, if I could say, where copyright was afforded to that original work, and then a new work is created that is so distinguishing that can also be afforded. With Gen AI, that original work was never afforded copyright to begin with. So the issue is less about whose rights. There's a identified right, that person owns it, and I need their permission to use it. In Gen AI, we don't know. Do we need someone's permission to use it? Does it look like a painting that someone did 10 years ago that is worth a lot of money and sitting on a museum wall? So there's so many questions with respect to the original sort of outputted work, and for which is a reason also why our agencies tend to do exactly what you just said, right? Not just rely on the output, but then use that output almost as a base or concepting to develop and then make sort of a further product. And at all times, we're always advising our agencies that everyone's talking about it. Just have the conversations with our clients. This is what we did. These are the prompts that we made. These are the differences that we've made. And then it's not a matter of shifting the risk and liability to the client, but it's a matter of having the open discussions and saying, look, here's where WPP's or our respective agencies' point is of risk. This is what we're willing to take on. And if it's beyond the risk appetite of WPP or the respective agency, then we have that discussion with the client and say, look, this is too unknown, or this is too broad a use. This is going to be global. This is going to be absolutely everywhere. Everyone's going to see it. We can't take on that risk. But there are things that we will take on the risk with and have those conversations with the client. But yeah, again, transparency, openness, but yeah, issues that have existed forever, I think definitely play into Gen AI and how we use it.
Thank you, Chiara. Thank you, Kristen, for the question. Chiara, I'm going to ask one of the folks who put in a chat to unmute if they would. And I hope I'm pronouncing your name right. Sahil, is it?
Yes, that's correct, Sal. Hi.
Hi. So please.
Right. So, sure. So, Chiara, there's certain copyright statutes that refer to computer-generated works, and they say that the humans who made arrangements for such work qualify as the author. Could this concept also be applied to AI-generated output, which is in response to prompts that are inputted by humans?
Yeah, I think the difference, and it sounds like you could definitely talk more intelligently to those legislations that you're referring to in that space, rather than I can. But I can speak in the advertising world and the sort of the creative Gen AI platforms for which I'm sort of have been referring to throughout this conversation. At the moment, the law has been quite clear, but how, I mean, I'd be interested to know with the platforms for which subject to or could be subject to those respective laws which do permit ownership rights to be applied, what the integration is between sort of the human and the technology, because I think that's where this sort of image output, video output, creative output is going to go. I think there's going to be more discussion around the reliance on the human versus the reliance on the technology, and what is ultimately, could or could not be owned. Not to mention the technology itself is created by a human. I think it's very interesting. I really do. I just think it's bizarre. But yeah, I'd be interested to know with the programs that you refer to, and knowing the generative AI platforms that we use in our industry, what are distinguishing features that you could draw between the two? Because I think that would be an interesting point to sort of consider with respect to where the law might go with these Gen AI platforms.
Thanks, that's insightful, Chiara. Yes, and I think a lot of the answers would depend upon the value and the amount of input that's actually fed into the system. I mean, like you said, if it's paragraphs of text, which actually has a lot of value, and that leads to creation, then this could be an easy answer. But otherwise, I mean, we'd still have to wait and see how the law catches up to this. Thanks.
Yeah, and I think what I haven't seen much about this, but I think about this, the identity of the person making the input prompts. At the moment, it's, well, some platforms obviously have restricted access you can pay for, but ultimately it's available to everyone, right? I mean, anyone, a 3-year-old could get on a computer and, make some sort of a prompt and they're going to get an output, versus more sophisticated platforms, which perhaps in the computer worlds, the ones that you sort of might be referring to, you need more than just a finger and a keyboard, right? The types of inputs that are required to create that output. And I think also the difference is, and I draw this distinction, again, like I made at the beginning of the call about generative AI versus traditional AI. Generative AI is always going to produce an output. If you put a period dot in ChatGPT, it's going to come back with something. If you put into, Stable Diffusion or Midjourney, cat, or if you misspell a word and you called it, it's going to come back with something. That is the nature of generative AI. That's how it's built. It will always produce something. With traditional AI, and perhaps those, platforms in other applications, don't always have to produce something. So if there's an input for which they can't understand, because the rules, how it's been programmed, can't produce an output, it won't produce an output. It's not forced to. And I think of the example of using Siri or any sort of the Amazon AI platforms, which you say, if they don't know the answer, you say, Siri, what is happening in Ireland today? I mean, that's pretty generic. They'll probably give you some sort of answer, but if you ask them some personal question and they don't have the information in order to sort of garner a response, they're going to say, I don't know the answer to that. Generative AI is the way that and that I think it's such an interesting distinguishing feature, is they're always going to output something, which also leans into these potential issues of, well, if you're always going to output something, then where's the threshold that's on the floor?
Thanks, Chiara. So I think all we can say conclusively at this point is that lawmakers did not have this in mind when they were coming up with, the concept of computer-generated works. So we'll have to see how this is addressed in the future.
No, there have been several amendments to the Copyright Act over time that have addressed advances in technology, but certainly nothing of recent, certainly nothing recently that has addressed this boom.
Thank you.
And thank you. Chiara, this is a quick question before we move on to one with a little more depth to it, but perhaps it's more your observation, but whose laws are you finding more stringent? US, EU, UK laws? What's your experience?
In terms of, if we're talking about ownership, then there are ownership rights sort of afforded in the EU and UK. So just as a blanket, I think that's obviously less, ambiguous, at least, whether we want to call it less restrictive. But also the UK are always, not always, but I mean, they were with GDPR and they are again here. They already have laws in place. You know, we have the executive order from last October, and there, like I said, I think there's been like 14 bills that have been put in front of Parliament. There are put in front of Congress. There are movements being made, and constant sort of narrative by Joe Biden about America being at the forefront. But there have actually been movements in the across the EU and the UK. So what's more restrictive? I mean, arguably, the EU and the UK right now, because there are enforceable laws for which penalties can be huge and really debilitating. The monetary penalties. So they're in place now. They're not enforced, and I don't know when sort of the cycle is of enforcement. But you know, arguably, are they further down the road with you know, sort of the drafting of the legislation and the implementation? Yes, but I'll add one other point, just as a high level, that the US is a lot more litigious. So I think regardless of how we will ingest quite a bit of, you know, learnings from the UK and those regulations, but regardless of sort of how we ingest and what the output in the regulations are, I think just naturally we're just going to see a lot more here. I mean, it's the nature of the beast. We see it across everything.
It's good observation. Nicole, I see you unmuted.
Oh, I'm just going to say we have another question in the chat.
Actually, Kathy, good to hear from you. Good friend of mine. Kathy, would you like to unmute and ask your question?
Hello, yes, I would. And thanks so much for doing this. This is just so helpful. I had a question if there are people or organizations, services out there that can research these issues similar to how a musicologist helps clear new music creations of copywriter status for those new compositions.
I think your ears were burning yesterday, Kathy. I was just talking about this exact topic.
Oh.
And with the exact parallel inference to a musicologist too. So, so that's uncanny, because that you're exactly right. That the role that a musicologist plays is so integral to trying to or attempting to sort of prevent any sort of claim of infringement with respect to whether it's a new piece of work, a completely new song, or perhaps a song that has different words based on the original composition or melody. And it's like a stopgap. I don't know of, and that's not to say anything because there might be, I don't know of any sort of body or you know, a private company that sort of has put their hand up as a way of you know, giving those assurances. And I think, and again, it's a musicologist is an expert in music. Someone that would do that parallel role in the Gen AI world, they can be an expert in trademark and copyright. Plenty of those exists. They're lawyers, but do lawyers sort of stand behind everything and say there's absolutely no way that there is going to be a claim with respect to copyright infringement? There's no way. Like, it's so much. And similarly, musicologist doesn't say that either, right? I mean, there's always going to be that potential risk. But I think it's interesting because of the background of a musicologist versus sort of just the nature of the background of people that would be giving that advice. Unless it's more of a consulting service and, you know, more, you know, advisory than it is sort of making more concrete assurances. But yeah, that your ears must have been ringing yesterday. Just made that exact parallel.
Yeah, and that also would be the timing if someone had exclusivity to that, or if the two fast food restaurants happened on the same images and they're out there at the same time, or if that's,
yes, who has a claim against another, exactly. And that in those sort of, you know, scenarios, you'd be looking at different ways to pursue in the event that you wanted to, right? You wouldn't rely on, you know, the Copyright Act to bring, or, you know, other similar regulations. You might rely on things like, you know, the negligence of your agency to, you know, not know what was sort of out there, or what, you know, there might be other sort of ways. But if someone's upset about something, if someone's got a gripe, I'm telling you, they don't go to, you the internet and Google the act and see if they have a case or not. They're going to make a case anyway. They're going to rely on something. They'll pull it, anything. So.
Well, I'm very interested to hear about SAG implications.
Thank you.
But where do we start?
Thank you.
Thank you, Kathy. Chiara, I know you've got a bit more to cover, so why don't we turn it back to you in your presentation?
Yeah, sure. I just had one more example here. The Google Gemini platform, it launched a new feature it's just basically an image generation feature back in February. And if you didn't hear about it across social media or in news outlets, they were accused of, if you will, overcorrecting on diversity with respect to the outputs of their system. So the notion of bias and the ethics around bias has definitely been an issue that many have discussed with respect to these generative AI platforms. These issues about, well, the data that they're ingesting, is the data just a reflection of society or not? Where is the data being ingested from? Are there implications with respect to one organization with certain values and with certain sort of target audiences be set up one way versus other systems that are set? So there's lots of discussion about the outputs of these systems, but when I think of it, I less think about concern about the output, but I'm looking at, well, how did we get that output? Well, what's the underlying data here? Who's in control of this? Where did they get it from? Who are the engineers? But anyway, there was a lot of critique about this. So Gemini came out within a week, I think, or something. Google took it down. They said they would release it in a few weeks. They haven't released it again yet. It was a huge launch for Google. It's trying to keep up with all these other platforms that are out there and making a lot of money. But they, again, I'm using the phrase overcorrected. But if you didn't see it on social media, the application or the new feature was producing historically inaccurate images when people were making prompts about historical figures. And they were sharing the inputs with the output, and Google were ridiculed for making such a huge error. And again, I'm not just looking at the output and how ridiculous it is and all the commentary on social media, but I think it's really reflective, or could potentially be reflective, or there's something to be said about Google and the construction of their Gemini feature. And again, there's so much commentary about this, and I don't want to sort of go down political, cultural lines here, but it's really interesting. Anyway, they made a big blunder, but bias being one of these sort of main or one of the ethical issues that has really cropped up again, that politics is looking at as well as another sort of social policy for which they want to address. Are there any more questions? Because my next couple of slides are pretty boring. They're more about, but I'll click to them anyway. So I've just provided here, I mean, obviously I am in-house at WPP, so I'm coming at this from that perspective, definitely. And we, as many agencies do, have policies, practices, have extended policies on what we had originally on about security practices, etc., and data privacy with respect to AI, but we've also come up with new principles, new practices, new policies. And these are just some of the sort of 6 highlighted points here, which we look to when we talk about mitigating or at least minimizing risk. And I spoke about transparency before. We have, like I said, policies, and what I'm seeing a lot is clients having their own policies, and not the policies for which they are advising their own employees, but policies for which they're giving to their suppliers who for which they want to follow. So not just our biggest clients, but across the whole spectrum, I'm seeing these policies pop up. So which is incredibly helpful if we're going to do the best work for our clients, but within the confines of their their risk margins, like we need to be able to know what those margins are. Again, I mentioned T's and C's. Yes, look at them. At WPP, we've also created this traffic light register. A lot of work went into analyzing a lot of generative AI platforms, and it looked across the T's and C's. It looked at issues like ownership, etc., to determine to basically assign each of the platforms in the register a red, orange, or green color, for which then we use to guide, or the system is actually open to our agencies. They can access it directly. But it's used as just sort of a high level guide so that people have somewhere to go and don't necessarily have to deep dive into the T's and C's straight away, but there's a pretty sort of simple register to go to. Yeah, human oversight, always. It's not just, it's not the solution. We can't just let, it's not a robot, an advanced robot for which we can just allow to service our clients. It's just another tool of many. And what we are always highlighting is, regardless of even if it's considered a green traffic light a platform in our traffic light system. I mean, everything, if it's going to be used commercially for our clients, we want to see these things. Are we going to be having this sort of oversight in a couple of years? I mean, hopefully not. It's a lot of review and work. But while the technology is so new, and while our agencies are leaning into it so heavily, it's important for us to be right there with them and making those decisions. So we stand behind that the legal process for us, it hasn't changed. The reliance on the platforms for, obviously, as we spoke about at the beginning, we can't rely on these platforms for not infringement. Even if like I said, the output is sort of entirely new, there's still absolutely infringement issues that we need to work.
I'm sorry, Chiara, to interrupt, but I'm thinking, anyone in the call, do you have similar processes or changes to your processes that you might want to make comment on here? Questions? All right, you can unmute if you do want to add to this.
Yeah, I guess, hi, this is Heidi Young. I'm with Publicis Group. So one of the things that I mean, a lot of what you're talking about is actually, of course, quite similar to everything that we're dealing with. I found, just as an overarching thing, that we've got clients who want to have nothing to do with AI, and then all the way on the other end of the spectrum who embrace it, who have their own, working groups that want to work with us. Do you find that you deal with that same spectrum, and how do you deal with that?
Yeah, I think when we say, clients who want nothing to do with AI, I usually find it's, perhaps a compliance body within the client that want nothing to do with AI, but the creatives working with our agencies teams, want everything to do with AI. So yes, I see the spectrum, and I think, look, if a client wants everything to do with AI and wants to lean into it, I mean, we have clients, if they're technology forward, they want that to be all about their brand. They want everyone to know that they've created this new campaign because it was empowered by, Gen AI. And then there's others that lean into it for different reasons, sort of, notoriety or brand, newness of campaigns. But at all stages of this, I think it's about, we at WPP have our own risk appetite, as I'm sure you do, based on policies at your agencies. But, also equally as important is, what is the risk appetite of the client? What are they willing to take on? I mean, they might want to lean into AI, all day, every day, but don't want to take on the risk. And we sort of firmly take the position that we have a certain appetite. And if their appetite is more than that, then we can extend more than that. But there has to be some sort of shift of responsibility and liability. If it goes the other way and we have more of an appetite, and the client has sort of less of an appetite, then yeah, there's that, room there for which we'll feel confident if it's across sort of, I don't know, Getty or Shutterstock or a platform, or not just the rights holder platforms, but sort of other platforms which we've assessed sort of that are lower risk, or if the use is lower risk, then we'll take on that risk.
So that's where transparency is, like, that's, as you have in point number 1, transparency, because then you can address all of the other ones. Yeah. Okay.
Thank you, Heidi. Brian, it's always good to hear from you. You have a question, I think, and maybe you want to go out to the whole group. Do you want to unmute,
Sure.
Brian? Good to-
Sure. There was an article in Ad Age like 2 days ago saying, I mean, it's kind of old news, but they were reporting it as kind of new news that clients are saying in MSAs that agencies can't use AI. And I think really what's happening is clients are saying that they shouldn't be using AI without disclosure and permission. But I know a lot of agencies are probably pushing back on this because they're arguing that there are certain types of use of AI. Basically, hey, we're not going to input personal information. We're not going to put in your intellectual property. We're not going to put in any confidential information. Why do we need to get permission from you for that kind of use? It's not necessarily that much different than doing a Google search. And I was just wondering if anyone wanted to comment on the call about how they saw this playing out with clients and negotiations.
Happy for anyone to jump in.
Yeah,
I
I
can-
think
I can
I
kickstart it.
think
Go ahead,
some of that
Heidi.
is educating the client. I really do, and in all the things, Brian, that you're talking about, because I think once you unpack some of that stuff, it's just I think there's an overarching with some clients like just fear, right, of AI. Everything
right.
you read, it's just like a scary unknown thing. But for us, I think when we have those kinds of issues, it's just part of a matter of educating them. I don't, there's kind of no other way to. I don't know if you agree, but
I think it's similar to, and I think you're exactly right in that when they're putting that language in, they're not saying, no, don't use it, but they just want their permission. Because like, I see it all the time still now, but remember when everyone was adding into agreements with clients that agencies weren't allowed to use software? You can't use, software in your implementation of. So I think it's a sort of a similar sort of vibe to that, where it's almost like just like a fear around it, or okay, that topic has more risk. That like we're just going to kick the can down the road and say no, and then we'll create exceptions to the extent that we feel comfortable doing so when we actually start concepting and the campaign or the work, etc., starts unfolding. But yeah, I think you're exactly right. I think it's not no, you cannot use it, but more let us know. And then as for yeah, I mean, how do you? I like what you said there. I mean, we can do Google searches. We can do image Google searches. We can do reverse image searches on Google, etc. And then maybe AI will get to a point where there's it's not going to be so front of mind. But I think it's just the fear factor, honestly, which is just so which is leading perhaps the additions of clauses in our client agreements about that. I haven't seen no, you cannot use. I have seen pretty complex, clever language about how it can be used and some sort of shifting of risks. But I haven't seen a you cannot use. But yeah, I'll be on the lookout now.
But I do think, this is Candace Kirsch, I do think in these agreements, it is, I think, putting everybody's together with, as Heidi said, you do educate, but then you have to parse through the language to make it clear that the use of AI in a manner that would legitimately concern them is you need permission. But every other use of AI that's part of your normal practice, you can carve out. And the clients are amenable to that, because they really, as long as you can give them the comfort that anything for which they would legitimately care about is disclosed, then I don't think they're looking to, at least in my experience, to really hinder your ability to do to work.
Yeah, just like perhaps people might, before this boom have gone on to sort of Shutterstock or other platforms just for inspiration, right? We were talking about sort of, the division between what a client would care about versus just being able to use it. Yeah, we're pulling our agency creative teams are pulling on creative concepts from lots of different means, and this is another.
And frankly, these days everything uses AI. Photoshop uses AI. When you type an email, it finishes your sentences with AI. I mean, again, it's trying to just bring it into things that the client, as opposed to this general category, is legitimately concerned with.
Thank you, Candace. Good to see you.
Good to see you
And
too, Sal.
Chiara, we are at the top of the hour. Is there anything you'd like to finish with before we sign off?
Look, I think we could have this conversation again in a month, and it'd be all, potentially could be, completely new. I think it's so interesting, and it touches just the entire advertising production process. Well, actually, one thing I will touch, we didn't get into SAG after and the potential implications that the new negotiation is going to have on use. I think there are some pillars for which we can look to, that for which commentary that's already been made, and then the voice actors for animation film, I think, was ratified last week, and there was some commentary in there. So I think between now and next year, when the negotiation or when it's ratified, the next version, it's going to be really interesting. But it's also going to be I think it's going to be less about SAG is saying this is how it has to be, and I think we're going to have a seat at the table. I think they're really going to rely on us and what we're seeing in order for them to sort of formulate their framework around, how they can sort of, attribute their, whether it's sort of session fees or where residuals should be, applied versus not. And at the forefront, we all want to protect the rights, and we don't want to circumvent anyone in the talent industry from being able to, make money off their name, image, and likeness, etc. But there is, it's going to be interesting. I think they'll listen, but famous last words. We'll see.
Well, that might be phase 2 then of our discussion here, but not for today at least. So, Chiara, we really do want to thank you for taking time to be with us, sharing what you have on this, and everyone on the phone, certainly thank you for joining us, and we hope to see you all soon again.
Thank you so much. Thank you, everyone.